Welcome to Aging Insight with your host, John Ross and Lisa Schollmeyer. This program is made possible by
Welcome to Aging Insights. I'm Lisa Schollmeyer, and I'm here with John Ross. We're elder law attorneys based here in the Arklatex, and we bring this program to you every week so that you can get educated about the issues that are faced by seniors and families that are assisting seniors when it comes to health, housing, financial, and legal matters. You know, Aging Insight covers a little bit of it all. So, welcome, John.
Yeah, well, and we try to cover so many different things because there's really so many different things that impact you as you get older. Whether you're talking about your own personal needs or whether you're talking about the legal concerns that other people around you may have. So we talk a lot about, planning for long-term care. And frankly, to me, that's really the planning for while you're still alive is the real important planning. What happens after you're gone? Well, you're not going to care.
And I always tell everybody, hey, your stuff will take care of itself one way or the other.
That's right. But when you do have that loss in the family, there are a number of questions. One of my childhood friends just recently lost his father, and he was calling me the day of the accident to say, John, I just don't know what to do.
Yeah, don't even know where to start.
I'm lost. I'm completely lost. And once you get past that first couple of days, everything slows down a little bit, and you get the funeral arrangements made, and all of that's fine. But inevitably, you end up maybe with a will, and somebody looks at that will and says, "Oh, geez, I'm the executor of this thing." Right.
And a lot of folks have never served as an executor. It's not a particularly common thing to do. And of course, there's a first time for everyone.
Absolutely.
I have met a few clients who have served as executors for their parents and aunts and uncles, but most people that we visit with, as they bring in that will and they've lost a family member, it's their first time serving as an executor, and they are lost.
May even be their first time ever even visiting with a lawyer.
That's true.
It's not uncommon for people to be sitting down with me, and it's the first time they've ever actually sat down and visited with an attorney. And like you said, they're lost. They're wondering what it is they're supposed to do. They've got this paper, and it says that when the person dies, here's who's going to get their stuff. And then it says that this is the person they're putting in charge to make it all happen, and they're lost.
Well, and John, sometimes I'll get that person who's coming in to visit with me only because after they got that will, and the will, stated that this individual is to serve as executor, that person having the will thinking, okay, well, let me start making some phone calls and, talk to the financial company and the IRA and following up on some things because I'm the executor. And what they find is when they contact those third parties and reach out to try to take care of the decedent's business, just the fact that the will says you are appointed or nominated as the executor, that does not yet make it legally so. And so that named executor runs into trouble. They can't take care of business because they do not yet have an order appointing them as an executor by a judge. So John, I guess that's the first thing as we're visiting with someone who's brought in a will. If there's a need for an administration or probate, the first thing we have to do is get them legally recognized as an executor.
Very, very common misconception that by naming somebody in a will that person is the executor, and they're not. The only person that can appoint an executor is a judge. When you do a will and you nominate an executor, you're making a recommendation.
Yes, you're making your preference known to the court, who you would like to serve as your executor, but the court gets the final say.
Right, but imagine I've got this friend and he seems like a super nice guy. His name's Charles Manson, and so I think, this super nice guy, Charles Manson, be a perfect executor. So I nominate him as my executor. Many years goes by. Everybody finds out that Charles Manson is a crazy mass murderer. I die. Charles Manson is not the executor. And even though I recommended him, the court is not going to appoint him because he's a bad character. So again, that's your recommendation, but ultimately only the court appoints an executor. And so for those families that come in and they say, well, my brother is the one who's the executor in the will, and he's already taken everything out of the house and taken it down to the pawn shop, he's not the executor yet.
Yes, I had that conversation last week with a client where, in fact, they were at mom's house, and this was several siblings, and one sibling came in and told all the others they needed to get out, and I believe this was during a visitation, like a wake, and waving the will, saying, I'm the executor, you all have to do what I say. It even got to the point where the police were called, but yet that will, a judge had not yet appointed that sibling as the executor, so all of that waving that paper around was meaningless.
That's right. So ultimately, it's the court that appoints you as the executor. So let's assume for a second that you have gone through the process and the court has waved their magic wand and designated you as the executor. That's the beginning and not the end of your responsibility. So what we're going to do is we're going to take a break here, and when we come back, and we're going to talk about essentially, once you're that executor, what is it that you're supposed to do? What can you do? What can you not do? And we're going to talk all about all of that sort of stuff here in just a second. So stick around. We'll be right back.
Hi there. I'm Larry Sims. It's been my privilege for the past several years to be a volunteer board member of Hospice of Texarkana. And there I'm able to represent community members like you. We continually customize our end-of-life care to better meet the needs of our community. As an example, our medical director and nurse practitioner still make visits to homes and facilities. Call today to learn more about the help we can give your family. Hospice of Texarkana, the nonprofit hospice established in 1985 for the community, by the community.
The Wadley Senior Clinic has been such a blessing for our family. Because they specialize in geriatric care, they take the time to really focus on Dad's needs. Their exam rooms are specially designed for seniors, and they offer lab and x-ray on site. With monthly educational programs on health and wellness of the mind and body, our healthcare questions get answered. Best of all, they accept Dad's Medicare benefits. See what the Wadley Senior Clinic can do for you. Wadley Senior Clinic, where healthy relationships begin.
Welcome back to Aging Insight, everybody. I'm your host, John Ross, here with Lisa Scholmeyer, and today the title of our discussion today is, so you've been appointed as the executor, now what?
Now what? Yes.
And so, we started off by talking about the fact that being appointed as the executor means being court appointed as the executor, not just being the person on that piece of paper. You've got to go through that process or else you don't have any power. But once you go through that process and you are now appointed as the executor, that's really the beginning. You've got a bunch of duties that you've got to do.
And I like that term, duties, because essentially when you seek an appointment by the court to be appointed as the executor, or you accept that appointment, you are accepting all of the requirements and duties and obligations that an executor has to properly gather the assets of an estate, inventory and account for the assets from the estate, figure out what debts the deceased might have owed, take care of all of that, and do it in the proper way that is dictated under the law. So you are promising that you will follow all of those rules and requirements as the executor, and you are also promising that you will do right by the beneficiaries of the estate of the deceased. And that means if you're the executor and you may not, if you don't like one of the beneficiaries and don't think they deserve something under, that's not your decision. You are promising you will uphold the will and take care of your duties the way the law requires you to do so. So let's kind of break those down as to what those duties are.
So the first thing, when you're the executor, the moment you're appointed as the executor, you essentially become responsible for the protection and preservation of the estate's assets. And the executor is specifically charged with gathering up those assets. Now, when I say gathering up those assets, that doesn't necessarily mean going into the house and sticking everything in your pockets and walking out the door. It can be as simple as making sure there's new locks on the doors, or calling a bank and saying, hey, I've been appointed as the executor, don't let any checks go out. So the first thing is you're supposed to start gathering up everything and getting an idea of what that person had, whether we're talking about financial assets, whether we're talking about real estate, whether we're talking about their personal property. Start gathering up and figuring out what all of that is. Once you figure it out, though, then you got a whole nother thing.
Well, and the other thing I wanted to say, John, with regarding to preserving and gathering up those assets and protecting those assets, insurance. You need to make sure that the assets of the estate are properly insured. If there are vehicles that are part of the estate, farm equipment, real estate structures, at this point, whether or not the deceased decided to carry insurance on those property or not, now you have an obligation to preserve and protect that property by doing so.
That's right. You're holding it for the beneficiaries.
Yeah.
Even if you are also one of those beneficiaries, you're really two people. You're the executor and you're a beneficiary. But there's other beneficiaries out there, and you've got to look out for all of them, and not just them. But you also have to look out for any creditors and stuff that might be out there, and we'll talk about that in a second. So once you've kind of gathered up and figured out all of these things, one of the requirements is that you file an inventory with the court. Again, this is a court supervised process, and there are some simplified ways where the court has less supervision. But the court always has supervision, and one of the first things the court wants to know is what's in the estate.
Right. Now, there are some new laws in Texas that will actually allow an executor to file something called an affidavit in lieu of inventory. And this is simply saying that you as the executor have prepared an inventory and you have sent it out to all the beneficiaries who are entitled to receive the inventory, and you are swearing to the court you have done that and taken care of that aspect of business, but you are not filing an actual inventory with the court. This is something that the Texas legislature has addressed due to privacy concerns, but it's not applicable in all estates. And regardless, you as the executor still have the obligation to prepare that inventory and provide it to the other beneficiaries, whether or not it is required to be filed with the court. Because if a creditor comes back and wants to know what the estate contained, you're going to have to pull that inventory out of your file. So as executor, you certainly prepare the inventory regardless of what your requirements are for actually filing it.
That's right. There's another big organization out there that also wants to know that you're now the executor, and they are called the IRS. Just because a person has died does not end their tax obligations. If that person has received income during the year, they're still going to have to file a final tax return, and it would be the executor that files that final tax return on their behalf. In addition to that, if the estate earns any income, so for example, if a person had a rent house and they died in July, in the middle of the year, Well, their personal return, they're going to have rental income that needs to be put on their final tax return. But that rent's going to keep coming into the estate until the estate is finally resolved. And you're going to have to, that executor is going to have to file an estate return as well. That's a Form 1041. And the IRS wants to know immediately who's going to be responsible for all of these taxes. And so you have to file a Form 58, I believe, with the IRS that just says, hey, I'm the executor, so if there's any tax things, let me know. Now, before you get too worried, that doesn't make you personally responsible for the taxes.
Right. It makes you personally responsible for reporting to the IRS about the status of the income from the estate.
Right, but if for example, you were the executor of estate of a person who owed more to the IRS than they could ever pay, well, you're personally not going to be responsible for any excess. The estate and whatever assets the estate have may end up going to pay taxes, but you personally are not responsible for it. You're just personally responsible for getting the IRS what you can get them out of the estate, but not out of your personal assets. So got to let the IRS know, and the other people you've got to let know are any potential creditors out there. And these would be people that the deceased owed money to.
Right, and you know, a lot of folks see that notice to creditors in the newspaper quite frequently, where it'll discuss, you know, so-and-so's been appointed as the executor of the estate of, you know, so-and-so, and any claims or creditors need to come forward and make their claims within the next, you know, the time prescribed by law. That is an example of an executor taking care of their obligation to let the whole world know and any creditors know that there is an estate open for this deceased person and that the executor is acting on behalf of that person. So that is one way to let creditors know there is an estate. The other obligation an executor has is to send actual notice, so mail some actual letters to creditors that we know of for sure. For instance, if there was a car note that was being held by a finance company or bank, then by the deceased, then the executor needs to send a letter saying that they're the executor and they're, you know, the estate's open for claims. If there's hospital bills, credit cards, and we have account numbers and addresses, the executor needs to ensure that actual notice is sent to those creditors we know about. And, you know, of course, I'd suggest that happen by certified mail.
Yeah, always a good idea because you don't want them coming back saying you didn't do your job.
That's right.
And it's important to get those notices out, because just because a person owed some money at their death doesn't necessarily mean that those people are going to get paid. And there's a whole set of rules as far as who gets paid and when and how. And all of that starts by notifying these people that the person is dead and that they now have an obligation to, if they want to get paid, to file a claim. It's a common mistake. People say, oh, well, I got a bill in the mail and I'm the executor, so I'll just write a check for that bill. But it could be that check should have gone to somebody else. And if there's not enough money to pay that somebody else, you as the executor might get in trouble.
Yes.
So you want to be very careful about that. Well, there's a few other things we want to talk about when it comes to what you need to know about being an executor, but we're going to save that for our last segment, so stick around. We'll be right back.
As things get older, they require more care. This car and I have seen a lot of miles together, but because I take care of her, she runs just like she did in 1955. That's why I chose the Wadley Senior Clinic, with an individualized care plan designed just for me and a convenient location off Jefferson Avenue. They have everything to keep me running like new. It's not about the miles, it's about the journey. Let the Wadley Senior Clinic keep you happy, healthy, and cruising down the road of life.
Hi there, I'm Larry Sims. It's been my privilege for the past several years to be a volunteer board member of Hospice of Texarkana, and there I'm able to represent community members like you. We continually customize our end-of-life care to better meet the needs of our community. As an example, Our medical director and nurse practitioner still make visits to homes and facilities. Call today to learn more about the help we can give your family. Hospice of Texarkana, the nonprofit hospice established in 1985 for the community, by the community.
Welcome back to Aging Insight. I'm Lisa Scholmeyer, and I'm here with John Ross. And today we're talking about, you've been appointed the executor of an estate. What do you do? What's next? So we've talked in our earlier segments that you have to be appointed executor by court order, and then you can legally act. And then we've talked about some of your obligations as executor, to let the IRS know that there's an estate open, to let creditors know that there is an estate open and that they need to file their claims. And John, another category of people that you need to notify are beneficiaries of that will. All beneficiaries, but we have some special obligations for charities and government beneficiaries.
That's right. So any beneficiary is entitled to notice that you have been appointed as the executor. You're supposed to notify them directly by certified mail, or if they appear in the court proceedings, well then they're already there. But one way or the other, you've got to notify all the beneficiaries. And you do have some special beneficiaries out there. Like I said, charities, government agencies, these nonprofit type organizations out there. There's special rules related to them, and it says that you have to notify the Secretary of State for that state. So if there's if you're doing this in Texas, and one of the beneficiaries, say they left $100 to their church, well, then one of your responsibilities is sending notice to the Texas Secretary of State that you are the executor of a will that includes a charitable beneficiary. So there's a few special exceptions out there.
Right.
So once you've gotten appointed and you've notified the beneficiaries, you've notified the creditors, you've gathered up the estate assets, inventoried all of that, provided that inventory to the beneficiaries or filed it with the court, still not over.
No, you still
still
not by a
over.
long shot. During this time, sometimes there's a lot of hurry up and wait when you're the executor.
Mm-hmm.
You have an obligation to preserve those assets and to keep them productive during the time that the estate is going on, but you are also accepting and receiving maybe creditors' claims and things like that. So you're going to have to pass some judgment on whether those creditors' claims should be paid.
Right, yeah, I mean basically once you start getting through all of this, once you know who the creditors are, you know who the beneficiaries are, and you know what is involved with the estate, now we can finally get around to talking about giving things back out of the estate. And here, this is where the executor, the law says that they have to prioritize who gets paid. And the first on all of that is funeral expenses.
Yeah, funeral expenses are the first thing that can be paid out of an estate. Expenses of last illness of the deceased, and administration expenses. So the cost of actually doing this probate procedure, the legal fees and the filing fees and those type of costs are a priority one expense of an estate.
That's right. There are also some family allowances, and for example, setting aside the homestead, which we talked about in a previous episode. There are certain family allowances that go out on top of any other claims. So if there are any of those that are appropriate in the estate, those would go out. Then you get into your creditors, and you have your secured creditors like a mortgage. Mm-hmm. And then you have your unsecured creditors like credit cards. And you make sure all the taxes are paid. Yes. File the final tax return, make sure all those taxes are paid. File the estate's tax return, make sure all those taxes are paid. And once you've got all of that taken care of, you can finally get around to paying the beneficiaries based on whatever the will says.
That's right. A couple of things about that. The beneficiaries, sometimes they don't appreciate how much time this process can take. So sometimes that can be a little aggravating as the executor of explaining it and say, trying to say, hey, I can't send you your, bequest at this time because I'm still having to pay creditors but you can make partial distributions out of an estate prior to the time to wrap everything up. But you definitely want to get good advice and guidance before you make any partial distributions out of an estate to
Right. Because while as a general rule, as the executor, you personally are not generally responsible for what goes on within the estate. If the estate owes more money than it can pay, that's not your problem. You pay what you can in the priority that's appropriate. But if you mismanage that estate, from the blatant where you just steal from it,
and we've seen that,
to people who just delay unreasonably.
Yes.
There are certain circumstances, because again, you got to remember, as the executor, you're acting in somebody else's best interests. You're not acting for yourself, you're acting for those beneficiaries. And if a court ever determines that you're not acting in their best interests, then it's possible you could be found liable. And that really could hit you personally. So yeah, you want to do it carefully, you want to do it right.
And then finally, you'll end up filing a closing report with the court to tell the court you've taken care of all the business and it's now complete and done, and you're asking the court to release you as the executor. So that's usually the final step.
That's right, and then you're done. And you did all of that because you had some good information right here from Aging Insight. And of course, you can stick around, and then next week we'll have another episode with good information. You can always call us on our radio show every Saturday at noon on 98.5 or pick up a copy of Aging Insight. But until next week, we'll see you then.
Bye-bye.
Thank you for joining us for this week's Aging Insight program with John Ross and Lisa Scholmeyer. This program is made possible by
Whether you travel for business or pleasure, staying fit and healthy on the road and in the air can be easier if you consider these tips. If you'll be leaving the country, make sure you have any vaccinations or medications you may need. Before you go and during your trip, try to keep up with your exercising and vitamin supplements. Get 7 to 9 hours of sleep the night before you fly. Pack healthful snacks for the trip, such as nuts, veggies, and fruits.